back on the record after an afternoon break and ready to resume with defendant's closing argument. Go ahead, Mr. Cooke.
Thank you. And, folks, I'm almost wrapped up here. There's only a few more points we want to make to help show you that the state just hasn't met their burden in this case. This really isn't a factor any longer, and the reason I'll assert it's really not a factor anymore is because this was not part of Dr. Cavallier's testimony at all. For all that the investigators made a big deal about, well, Kelsie, we didn't find any vomit in the closet, and this really means that somehow you must have strangled her as opposed to hanging. We didn't hear anything like that from Dr. Cavalier. Now, again, since we don't have any medical testimony about this, the defense position about the vomit is really common sense. If Chloe was found hanging in the closet and her neck is impinged, if she had to vomit, nothing's going to be able to come up because her neck is impinged. Once that impingement is taken down and she's laid on the bed, and as Kelsie told officers and investigators several times, when she reached down on her chest to feel she had a pulse, noticed that she had vomit coming out of her mouth. All of this was consistent with the scene. And absent some medical testimony that you're supposed to find vomit in the closet as opposed to other places, this is just an argument that investigators made to Kelsie Thomas to convince her to confess, that ultimately, as Dr. Cavalier demonstrated by her lack of indicating this was important whatsoever, tells you this is an argument. And so, like I said, this case, again, reminding you, came to the medical examiner's office as not suspicious. They conducted DNA testing. None of that helped prove that Kelsie Thomas was responsible for Chloe Chandler's death. They took a look at all the phone logs. Since probably the 90s, electronic media has been a substantial source of information for police. That's almost the first thing they do anymore, is confiscate a person's phone and find out where they've been searching, who they've been talking to. Usually, this is a treasure trove of information for police and investigation, and you heard Saren testify that they didn't find squat. Not a thing. And wouldn't you think that if, as the state alleges, Kelsie Thomas, in a fit of rage, strangled her daughter, think maybe she wanted to know what to do? Do you think Kelsie Thomas, the cook at Casey's General Store, is going to be savvy enough or confident in herself enough not to call anybody? Not to Google search on the internet how to make this look like a hanging? She didn't. And then there's Kelsey's life as a backdrop. And folks, like I said, if you look at everything that was going on in Kelsey's life, it seems to more fit a situation in which mom was just maybe negligent and left her daughter to her own accord too long. That's what we see here. We don't see a pattern of abuse. We don't see what we historically see in these kind of ongoing abuse cases where there's history of injuries, where these injuries have different ways to date them, where you can see that, you know, this cigarette burn was 9 months old, but this cigarette burn was only 6 months old. Those things happen in these types of cases, and it didn't happen at all in Chloe Chandler's case because she wasn't abused. All of this fits with what Kelsie Thomas had said. And in addition, again, if you're just looking at this from a common sense perspective, and you look at the injuries that Chloe Chandler had, does that look like somebody just snapped on her? If somebody just snapped on a child like that, you'd expect head injuries, maybe smothering something. This looked like a concerted, if this were an intentional act, which again, the state has no proof that it was, this was a concerted, constant thing that happened. That those pajama pants had to be around Chloe's neck for more than a second, certainly longer than Kelsie Thomas in her final confession said they were. And even if you don't want to give Kelsie Thomas the benefit of the doubt, which the law requires you to do, her story still doesn't make sense. It doesn't make sense. And this is the story that the state has necessarily had to adopt because that's what she finally said. Kelsie Thomas killed Chloe Chandler. Here's how she said she did it. And it doesn't make sense. And in fact, what she initially said, what she said all along, what she said for the first 12 hours of questioning, fits. It all makes sense. Not only in her statements, in her call logs, in the things that were not on her phone. Everything about this day fits with what Kelsie Thomas originally said had happened. And again, this dynamic, police talked to everybody Kelsie Thomas knew. They got her phone. They tried to discover every bit of information they knew about Kelsie Thomas to see what they could use to get more information out of her. You better hope that you're not in a bad part of your life when the cops come calling, because they'll know everything about you. And Kelsie Thomas knew this. Kelsie Thomas was not necessarily in a good place in her life, and she talked about those things at investigators' invitation. But she's also not going to hide from those things either. And just because Kelsie Thomas was frustrated with her daughter, as most parents get, does not mean that all of a sudden, after 5 years of Chloe being in this world, that for the first time ever, she's not only going to abuse this child, she's going to kill her. It doesn't make sense. Kelsie Thomas was living a type of life that made her an easy target. That's part of why 2 members of her estranged family had suspicions in the first place. And again, these suspicions were about her not being mindful of Chloe, not that she was abusive. None of this makes her guilty of killing her daughter. It doesn't make sense. And parents, and I think just about all of us, whether we're parents or we have siblings or whatever, our children are constantly putting themselves in danger in ways that they have no idea that they are. That's why they need constant vigilant attention. And that's why when you don't give them constant vigilant attention, like we know Kelsie Thomas was not that day, that bad accidents happen. Because kids don't understand the dangers that they put themselves in sometimes. This is what happened in this case. And again, keep in mind, folks, for all of the charges, if you look at all the alternatives, each one of them require you to believe Kelsie Thomas committed an intentional act in killing Chloe Chandler. This is not a case of negligence. It could have been charged that way. That's the state's decision, and it was not charged that way. They wanted to go all in. They wanted to assert that she was a murderer. And this is what this case is about, even though the facts don't necessarily fit it. If, to your satisfaction, the state has not established beyond all reasonable doubt.
Objection mischaracterizes the burden of proof.
Objection overruled. You can go ahead and proceed.
If you can't get past that burden beyond all reasonable doubt, to believe that it's at least not possible, there's not a possible way, not a plausible possible way that what Kelsie Thomas had said originally. No absolute way to know it happened. That's how you find her guilty. And when you, in looking at the two, and this is where we always kind of arrive at this point, because you've been hearing everybody go back and forth, and so in your mind you're thinking, well, who do I believe more? And again, that's not the proper standard. The standard is proof beyond a reasonable doubt. This is the state's work. They have to prove her guilty. And so, take a look at instruction number 4, the instruction on reasonable doubt. A reasonable doubt is such doubt as fairly and naturally arises from the evidence in the case. or lack or failure of evidence produced by the state. Do you folks not see how all of the evidence in this case naturally fits with what Kelsie originally said? It just naturally fits. It fits much better than the state's version. It really does. And again, it's not a contest. It's not who you believe more. The state has to absolutely put my position out of your mind completely. Could not have happened that way. If you think it's reasonably possible, you have to vote not guilty. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Are you firmly convinced that she's guilty at this point? Do you have that hesitation? You think, I'm going to make this decision, and it's fine. I have to be firmly convinced. And all this evidence really does line up with what she originally said. And we're not talking about, no offense to my client, some rocket scientist. We're talking about a cook at Casey's. Got all this stuff figured out. All the electronic stuff, everything that could be used to prove that she's lying, it just didn't exist. Think about the possibility of that. She could navigate all this and still allow me to make the arguments that I'm making? There's more than a reasonable possibility. It's in fact, I would assert, more likely that it happened this way. And again, I don't have to prove that to you. All I have to do is establish with you, not that it happened that way, but that it's reasonably possible that it did. When, in fact, like I said, folks, the reality is, it seems more likely than not. Ladies and gentlemen, Kelsie Thomas is not guilty. On July the 19th, 2018, Chloe Chandler was found hanging in her closet, just as Kelsie said. Everything that she did that day, everything that she experienced that day is consistent with that. For all the ways in which the state tries to trip her up, and yes, she ultimately confesses. In every way the state tells her to confess. And I've documented that for you. Go ahead. Watch the same interview. I didn't play for you any clips that you won't have an opportunity to see for yourself. I'm not taking anything out of context. Context is important. That's why I've been making such a big deal about this ever since jury selection. Can't just assume that because somebody confessed that they're guilty. Sometimes, given the tactics that we've been educated about, sometimes innocent people confess to crimes they didn't commit. And anybody can assert that, I agree. But not everybody who can assert that can point to undisputable facts of the case like I can. This isn't a false confession case because I got an expert to say that it is. Like I said, Dr. Cutler merely opened your eyes to what I just showed you. You've got a medical examiner who was not confident in her opinion. Even before you heard from Dr. Young, I can't imagine that you had a lot of confidence in her opinion in the first place. And even without Dr. Young, Dr. Cavalier testified that she did not make her findings until after Kelsie Thomas confessed. Confessed in a case in which the investigators knew the results of the autopsy and knew what the findings had to be, and you just heard the investigators tell Kelsie what the evidence needed to be. If ever there was a false confession case, I could not imagine how it would be supported more than in a case like this.
Objection is to counsel's own opinion. It's improper argument.
Members of the jury, you will make your decision based on the evidence. Arguments can include opinions of counsel, and that is not evidence. It's not what you base your decision on. Go ahead.
Ladies and gentlemen, I have made it clear. The state has not carried the burden. The It can't. The evidence doesn't support it. The evidence points in a completely different way. And again, I don't have to prove that to you, but you know it. When you go back there to deliberate, this isn't about who you believe more. It's about the state being able to put out of your mind completely the possibility that what I demonstrated to you to be true, they have to show that that's not even a possibility.
Objection mischaracterizes the burden of proof and the evidence, Your Honor.
Members of the jury, again, counsel's personal beliefs, counsel's opinions about the evidence are not what you must consider when you make your decision. You have to make your decision based solely on the evidence you have heard in this case and the court's legal instructions, which have already been given to you.
Because of the facts you know are true, because you know that the state has not met their burden, you must return a verdict of not guilty. Thank you.
What I say is not evidence. What the defense attorney says is not evidence. So he can get up here and twist what the burden of proof is. But you're going to see, and you already have in the instructions, that our burden of proof is beyond a reasonable doubt. Not all doubt, not beyond a shadow of a doubt, not beyond a scintilla of a doubt, beyond a reasonable doubt. And you do have an instruction to help you with that. But it is for you to determine what reasonable doubt is. It's not for the defense attorney to define it to you or to tell you what we have to prove about his case. We have to prove the elements as charged. It is a good and decent burden. It is a burden that we embrace. It is a burden that is met in criminal courts every single day. And it is a burden that we met in this case. The definition, like I said to you, for beyond a reasonable doubt is in your instructions. It's for you to determine. What does it mean? Given a fair and full consideration of all the evidence, you are firmly convinced of the defendant's guilt. There is no other result other than a verdict of guilty. We have proven our case beyond a reasonable doubt. Is counsel really insinuating for the defense that because the defendant didn't put anything, didn't send any text messages or didn't put anything on Facebook, that means that she possibly couldn't have committed this murder? It's asinine. We don't have to prove that. He wants to tell you and argue to you that Kelsie isn't smart enough to get away with murder. What? Because she sat there for 2 hours and figured out what to do to try to come up with this ridiculous story, hoping that people would believe it? Let's talk briefly about the vomit that counsel talked about. What the vomit shows you is that Chloe was never in the closet. Never. There was nothing in that closet to show that she was in there, including no vomit. And even if you want to believe Kelsey's story, wouldn't she have vomit on her? There's vomit on the bed because that's where this happened, after she took her and threw her onto the bed. The vomit shows where this happened. The vomits and the pants. Those corroborate her confession. The defense doesn't want you to believe her confession. All of these pieces of evidence corroborate it. The defense wants you to believe that our case, the state's case, came down to 3 things. I believe they said family, medical evidence, and confession. Well, it's not just that. It's the defendant's demeanor. It's all of the things that you were told about her family. It was her confession. Not just her confession, but the letter that she wrote. It was the phone calls that she made. And on top of that, it's her demeanor. It's her actions before and after. In jury selection, we talked about how you figure out a person's state of mind. It's based on their actions, things they do before or after an actual incident. I'm not going to keep going over the facts because I know you've all been paying attention. Think about all of these things. The defense wants to get as far away from Kelsey's family as they possibly can, right? They want to say they don't know her and only listen to the things that we tell you. First, Aaron told you at the beginning of his testimony they weren't that close. Counsel kept asking, and he's like, well, they were close, but not that close. Callie told you that she would come and she would take Chloe for weekends. She would come to Atumwa. We went through detail. She was there. She bought Kelsie her pregnancy test. She came for her graduation. She came when Chloe had her tonsils out. She came when she came for Kelsey's graduation with Chloe on her lap. She did hang out with her. And Brittany, also want you to believe that Brittany has nothing to do with her. Brittany told you that she would hang out with Kelsie about 10 times a year. You know how well Kelsie knew Brittany? So well that when this happened, she let Phoenix stay with her for about 2 days. You know why they're trying to get away from that? They have to separate from the family because of this letter. I love Chloe so much and never thought anything like this would ever happen. I just wish more of you would have helped me when I asked or tried to get me the help we all knew I needed. That's why they're trying to distance themselves from the family, because this letter corroborates what Callie and Brittany told you about the behavior that they witnessed prior to Chloe's death. And it proves that they were telling the truth about that. And the defense wants you to believe, they pretty much want you to believe everything, right? They want you to believe every single version, all the different versions that Kelsie said. So believe all of that, but just don't believe the confession. But if you believe all of these different things, that even corroborates this. Because she says in that first interview on the 24th that she asked her dad and then her mom to take Chloe. The defense keeps saying that all the stories, let's take away the confession at this point because, they just obviously don't want you to believe that. The story's always the same. You heard her story and it's always consistent. That's for you to determine. All of her stories are inconsistent. You know why? Because it's the shifting sands of the guilty mind. Because she starts telling one story and then she doesn't stay consistent, so she changes another fact and another fact and another fact. I know the counsel brought up the marriage example that we talked about in jury selection. And yes, there might be some things that you forget, but you remember the important details. You remember where the pants are and how they're tied. You don't keep changing that. It kept changing because she was being questioned about it. Because it was something she had made up. It wasn't the truth. When we talk about Kelsie's demeanor, counsel wants you to believe that Kelsie's demeanor was this way because she didn't have a good relationship with her mother. Remember what Dr. Young told us, don't make assumptions. You didn't hear any testimony about that. Callie admitted to you that she wasn't that close with the defendant, but she didn't tell you there was absolutely no evidence that said that Kelsie's behavior, her demeanor, the way she acted was appropriate when all of this happened. That's for you to determine. Like I said in my closing argument, you are the fact finders. You are the believability of the witnesses. You are determine what makes sense. And ask yourself if the way that Kelsie acted before and after this happened makes sense. Look at those videos when the officers are asking her questions. You determine. Counsel says that because Kelsie was, in fact, or appears to be crying on 911, that she must have been telling the truth. This was a traumatic experience. Whether you believe the defense's version or not, because guess what? Even if you, on your own, kill somebody, it's still a traumatic event. We don't have to prove that day Kelsie woke up and said she was going to kill Chloe. We don't have to prove that she was abusing her on a regular basis like the defense wants you to believe. We have to prove the elements as charged. And that's what we've done. We don't have to prove that there was a long term of abuse or injury. What we have to prove is what happened on that day. And we have. That she picked up those pants and that she strangled her with them. Now, one of the things that counsel talked to you about was expert testimony. And there's an instruction about that that the judge already read to you. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. So let's first talk about Dr. Young. First, about his inferential test and how he said that Dr. Kettleer was imagining a strangulation. He told you about assumptions and what assumptions what assumptions mean, and how Dr. Kettleer must have been making numerous assumptions. The doctor, who counsel said, I don't know how many times in their closing arguments, didn't do a finding right away because she was trying to get it right, because the initial story didn't make sense. She didn't just jump to conclusions. She didn't make assumptions. She said, this doesn't sound right. Dr. Kettleer told you about how part of her job has to do with dealing with the history, right? When you go to a doctor, you don't just jump on the table and say, fine, what's wrong with me? You tell them what's going on. It's the same thing with forensic pathology. And she talked a little bit about that, about how when she receives a body for autopsy, what matters is the information that's given with it, to see if it matches up. And in this case, she performed this autopsy. She was expecting to find marks that would be consistent with a hanging, and she didn't, because she saw that there were signs of a struggle. She saw that force and injury indicated that this was strangulation and not hanging. She said, this doesn't seem right. And yes, she didn't jump to a conclusion. She also did have when she later found out about the defendant's confession, she also told you that she continued to look at different types of things before she made that determination. Police reports, scene photos, other things, which came to her ultimate decision that this was a strangulation and not a hanging. Dr. Young didn't perform the autopsy. He didn't see Chloe's body. He said, if a witness provides an account of what happened and the account is consistent with findings, no reason to go any further. That's great, right? For anybody that wants to commit a crime, just come up with a story. Have Dr. Young as your medical examiner, because nobody's ever going to ask any questions. Why go any further or ask any questions? That's what he said, this expert, that the defense wants you to listen to and believe. No inconsistencies between pajama pants and Kelsey's version of what happened. So again, you just take that and you don't ask any further questions. This is a doctor who's supposed to be an expert in this field. You can't imagine or surmise past events because there's so many other stories that could be true. So just take it for what it is. Don't ask any questions, don't do anything else. A person, then he says on redirect, I don't know if you recall this, he said that a person trying to relieve strangulation usually scratches and marks from strangling on themselves. And he even, I'm sure some of you caught it, made the exact mark that Dr. Kettleer told you about and said, that's what you see in a struggle. That's what you see in a strangulation. Somebody trying to relieve what is causing them. That's exactly what Dr. Kettleer told you. That's exactly what happened in that case. And those marks prove that. Dr. Kettleer told you that it appears to be Chloe's hand marks and what looks like little scratches underneath it. That's exactly what Dr. Young said. He also said people are gentle on themselves when hanging themselves, meaning that they don't have struggle. But then he said, well, no, this is a hanging. He told you strangulation is a very violent death. So even those last couple things he said were consistent with what Dr. Kettleer said. Dr. Young talked about a lot of different things. I believe he even said it would be more, a suffocation by pillow would be more ergonomical for a murderer. Just the things that he said. You are able to look into his credibility. Think about the things that he said, his demeanor when testifying, everything that he said, the way he answered questions. Do that to all of the witnesses, and look at how incredible he was on the witness stand. You can consider that. You can listen to what you want to from him, or you can disregard his testimony completely. The defense also called Dr. Cutler and indicates for some reason that we don't challenge Dr. Cutler. Dr. Cutler performs lab experiments. He seems like a very nice man and way more credible, at least, than Dr. Young. But he at least got up here and was truthful. He told you what he does. He has never performed an interrogation on a suspect in a criminal case. He works at university. He conducts research. He told you about some of the different types of research or experiments that he's been a part of. One of those was individuals that are working on a computer and hit the backspace key, and the computer crashes, and then some of them give false confessions. Now, I'm sure that he conducted that experiment in the way that he said, but somebody falsely confessing to hitting a backspace key when they're a student in an experiment where there's no consequences is a lot different than somebody admitting that they killed their daughter. He told you that another thing that he does is he just observes interrogations. And I'm sure, again, that he looks at those interrogations and he does that. He talked about the method that he believes the police used, but Don Schnichter told you when he testified that he told you what approach he used and that he pretty much asked questions about what happened. When Dr. Cutler testified, he talked to you about different tactics. So a few of those tactics were report building tactic, acts with sympathy or is friendly. So that's one of the things that he says. So that's one of those numbers of that 300 that they talked about. So because now the police are being nice and trying to talk with her, that's just a tactic all of a sudden. Or evidence-based tactics, meaning that they're presenting the evidence. What are the police supposed to do? They would be remiss in their duties if they didn't ask questions. Are they supposed to just say, oh, that's your story? Okay, we're going to walk out. She must not have done it. Unfortunately, that's not the way the world works. There is absolutely nothing wrong with the way that those officers conducted that investigation. They talked to Kelsie about what happened. The defense wants you to believe that this was so coerced. You saw her demeanor during that interview. Does she appear to be somebody that was being coerced? She's swearing at the police. She's yelling. She's all over the place. She was not somebody that felt like she had to say whatever just to get out of that room. Most of the interview, she even has her keys in her hand. And go ahead, watch the tapes. Watch the interview about when she finally decides to confess. Her entire body language changes. She puts those keys down, and then she starts talking about what happened. Another thing that Dr. Cutler and the defense talked to you about was this theory of alternative questions. So you're either a monster or you were angry. Well, if somebody asks you, do you want to go to McDonald's or Burger King, you can say, well, I'd rather go to Wendy's. There's nothing that said that Kelsie has to answer their questions the way that she did. In fact, look through all of her the times that she says no to them, all the times that she doesn't agree with them, all the times that they ask her a direct question and she doesn't answer it. This is not somebody who falsely confessed because she was coerced by the police. The defense also wants to talk about, with Dr. Cutler, confession contamination. So they have to find a way to explain the phone calls in the letter, right? Because it has to be part of this false confession, because it's probably some of the most damning evidence. That letter that she writes, even if you want to believe that she's so coerced in that interview room, she's now by herself for 10 minutes while she's actually writing that letter, thinking about what to write. And we already talked about that letter. That letter that corroborates what her family told you, what she says in those earlier interviews. And then the phone calls. That first intake call is after she was arrested. And she says to her husband, I'm sorry, you weren't there. I didn't mean to hurt her. And even that one, throw that one out. Because even 24 hours later, is she still under these coercive tactics? Is she still trying to just say what the police want? At that point, she could have said to her husband, oh my gosh, I falsely confessed. They made me do it. No, at that point, now she's still saying, I'm sorry. I'm sorry, you don't understand. Dr. Cutler told you these tactics that he researches he indicated an innocent or guilty person would confess. He can't give you an opinion on whether or not the defendant was guilty or innocent. But you know, based on all the other evidence that corroborates her confession, that confession was accurate. The defense spent a lot of time talking about Kelsie's interview and what they believe were things that the officers gave her, the information they fed her. And I'm sure that you picked up on that there was even more than the defense obviously pointed out to you. And I'm going to just read to you some of the different things that was asked of Kelsie. Does this sound like somebody who was just agreeing with everything the police said? Did you drag her into the room when she was on that bed? No. Did you push on her? No, she heard me coming and ran into the room and jumped into the bed. What was her reaction then? Her eyes got big. I could see that she was scared. They did admit that the eye thing was something that the officers never brought up, because Kelsie knew that happened. Because she was there. She saw what happened to Chloe's eyes when she did this. When the officers asked her, do you think she maybe passed out, or did you see her pass out at all? She says no. She's not just agreeing with everything that they're saying. Did she ever say anything? And her response is, well, she was breathing really heavy and then her eyes got really big. Did you hear her stop breathing? No. It's not like Kelsie is just saying whatever they want. They asked her, they introduced so many different scenarios because they're trying to figure out what happened. They don't know what happened. They weren't there. Just because they're asking questions, that means they're using some tactic? They're investigating this. They have every right to interview and interrogate her and ask her what happened. Tell us what you found. Kelsie says, I found her. Her lips were blue, her eyes were closed, and she was pale. Were you able to see any movements from her at all? No, I grabbed her. I picked her up. She was just limp. It's Kelsie that says to them that she thought she was still alive when she left the room. It's Kelsie that says she put her foot down. It's Kelsie that says that it makes that movement that goes like this. Kelsie did all of those things. And you know what? Maybe they were onto something. Just because they started asking the right questions or because she had given them enough information to keep going, does that mean that it's a false confession? No. They were doing their job. They were asking her questions, and they were asking her questions because it didn't make sense. They knew, based on what they had already found in the house and based on Dr. Catalier's autopsy, that she did not accidentally hang herself. That's why they kept bringing up the evidence. That's why they asked her about it. And that's why when she first starts confessing, they keep asking questions. Again, when she starts first confessing, are they supposed to just say, okay, she did it, let's walk out of the room? It didn't make sense to them. Why? Because it didn't fit the medical evidence. And so what, they weren't just supposed to ask any more questions? That doesn't mean that they fed her everything or that she just said what they wanted. Again, you are able to determine based on that video whether or not Kelsie was telling the truth or not. Look at the things we talked about in jury selection. Her demeanor, her attitude, the way that she's acting. You are allowed to do that. You're allowed to evaluate that. Evaluate that video like you would do all the other evidence. Look at it in light of all the other evidence and ask yourself what makes sense. When we talk about that letter, counsel said that the reason why it's also, I believe, confession contamination is because they gave her the sheet of paper to do it. But as I'm sure you recall, before there's any talk about the letter, before Kelsie even gets to the final version of what happens, I'm not sure exactly what point of the video it was, but she says before they ever even say anything about her family, what am I supposed to tell my family? Then she says, what am I supposed to, am I ever going to be able to see my family? And that's when Don Schnichter says, we can talk about it. And it's not until a while later that he says to her that if she wants to write that letter, he can give her the paper to do so. Like I said, there's lots of different scenarios that the officers are asking Kelsie about. They asked her if she used a pillow. They asked her all kinds of different things, and Kelsie had no problem saying no. There's even a point when Kelsie starts confessing. Kelsie says, when I went into her room, she had jumped out of her bed and I grabbed the pants. I didn't mean, hurt. I didn't at least try to hurt her. I was just trying to get her from running away. Kelsie then says, so I used the pants and I swung them over her and all I did was grab. Don Schnichter says, did you pull the legs together like that? No, I didn't do that. And again, in that part of the video, her demeanor was so interesting because she doesn't just say no, she says, no, I didn't do that. She's very certain that she didn't do that. This is not somebody who's just saying what the police want them to say. Another big part of the facts that the defendant introduces, that the defense failed to point out, is the stumbling. How Kelsie talks about how Chloe almost fell to the ground, that she started wobbling, that she was flailing or moving. That's not something that they ask her about. Also, when we talk about the actual act that Kelsie talks about, when she says what she did with the pajama pants, it's Kelsie that says that she first grabbed her arm. All these little things, because if counsel wants to talk about all the things that they want you to believe that Kelsie adopted, let's talk about all these other things. Look at the videos. Look at all the other little things that Kelsie introduces herself. Because like we talked about in jury selection, Kelsie is the one that was there that day. Kelsie determines the crime scene. Kelsie determines what witnesses there are. Kelsie determines what evidence is left behind. Kelsie determines everything at that point. She's the one that decided to commit that crime at that time and to use the mechanism that she used. No one else was in that room that day. The defense wants you to believe that Kelsie admitted to additional facts that weren't even there. Well, Dr. Catalier told you that there was hemorrhaging in the back of her neck, in the back of Chloe's neck, and told you about how significant that was in a case of strangulation. That you typically wouldn't see that in hanging, and it makes sense. I talked about this a little bit in my first closing, but Dr. Catalier told you that when somebody hangs themselves, there's little or no injuries, that the noose goes up, that they go conscious within 3 to 15 seconds. The reason that's important is because it would show that within 3 to 15 seconds, if you believe this story, that that's the only amount of time that Chloe would have had to struggle. That injury didn't happen in 3 to 15 seconds. You can use your common sense for that. Injuries that are 4 layers deep. Even if you believe the end of Dr. Young's testimony, he corroborates that. He talks about strangulation and hangings and how you see injuries more in strangulations. That's why the police kept asking Kelsie questions, because her story wasn't possible. Because they knew that Chloe died at the hands of another person. This wasn't an accidental hanging. That injury, both outside and inside, Dr. Cavalier went over in detail and talked to you about it. That's why she couldn't immediately come up with a finding, because she knew that something wasn't right. She needed more information. I know this was just something counsel said, but counsel said something about how Aaron Thomas isn't here. Nope, this is the state of Iowa versus Kelsie Thomas, because Aaron Thomas wasn't home that day. Because we know from everything that it was the defendant that committed this act, from all of the evidence, from everything that happened. And just because she was savvy enough to send that text message or respond in the way that she did, that doesn't mean that she didn't commit this act. Look through those jury instructions. Nowhere does it say that we have to prove that she didn't make that phone call or any of those other little things. What the defense is trying to do is they're trying to divert your attention. They're trying to make issues out of non-issues. They're trying to get you to focus on things other than what the state has to prove and what we have proven in this case. Counsel talked a little bit in there, or quite a bit actually, about this parole example with Dr. Cutler, that there's absolutely no evidence. You have not one shred of evidence that this is a false confession. All Dr. Cutler told you was his tactics and his research, and that's for you to determine. For you to determine if you believe any of that is even relevant in this case. So counsel can throw out all these other examples and all this other stuff. What you have before you is what you have in this case, which are the facts and the evidence in this case. Like I told you before, you apply the facts to the evidence and use your common sense. When we talk about the pajama pants, Don Schnichter and Mike Searin told you why those were important. Those were important because the defendant kept bringing them up. The defendant kept talking about them. Like I said in my first closing argument, why are the pants on the bed? It just doesn't make sense. Even with all the other stuff, even if you believe the story, why would you pick up those pants and put them on the bed? It's because they were there and she didn't want to touch them. The defense would have you believe that this is some big conspiracy, right? That Dr. Cavalier is in on it, that the police are in on it, that Kelsey's family is on it. If they were going to make this all up, don't you think they'd make it better? This is the truth. This is what happened. What the police officers do in a case like this is they follow the facts. They follow the evidence. That's what they did. Who cares if at first they thought it was an accidental death? Because the police went there because that's what the defendant told them. Then when they get there, they just know it's not right. They know that this doesn't make sense. As the officers are investigating, they keep thinking this just doesn't seem right. No, it is ridiculous to think that a child would make a noose. And think about this, right? Chloe had learned to tie her shoes. To think, though, that she could tie a double knot that would take her life is incomprehensible. Adults sometimes know how to tie their shoes or do double knots. That doesn't mean that sometimes it doesn't come untied. This is a girl, no matter how much Jill Gardner tells you she knew how to tie her shoes, and I'm sure that she did, that doesn't mean that she could do it to this sophistication. They just want you to believe that. And not only that, think about how this would have had to happen, right? So generally, if you actually believe that she took the pants and she tied it in a double knot, think about it. A child that's learned to tie their shoes not long ago generally would tie and pull tight, right? They're not gonna know how to make an opening, pull it out, and tie it again. It just doesn't make sense when you think about when you apply your common sense. And then on top of that, it would have to be strong enough for her to know how to do that. She would have to jump into it, and then she would have had to have so much struggle while that's happening in that 3 to 10 seconds. It's not plausible. Those injuries are not from a hanging. They're from a strangulation. The defense wants you to believe that this is some easy target, or that the defendant is some easy target, that we're just putting a case on her. We want justice for Chloe. We want the defendant to take responsibility for her actions, for her choices, for what she did that day. They said that, the defense said that we're trying to prove that she had murder in her heart. Nowhere do we have to prove that. We don't have to prove that she had prior abuse or that anything happened with regards to Chloe and Kelsie. And we're not saying she's a monster. I'm sure she loved Chloe. However, she did this that day, and you know that because of the evidence. Everything points to her. We know that she did this, and we know why she did it because she actually told us. She was, in that moment, angry. And she was angry after, and she was angry before. She was having issues with Chloe, and that's why she did that in that moment. As I said to you about malice aforethought, I read you that instruction earlier. We don't have to prove that that state of mind element went on for any prolonged period of time. The minute she picks up those pants and starts carrying out the act and continues to do it, that is malice aforethought. Counsel also told you that we didn't prove intent. What other intent do you have when you do this, other than to commit injury and kill somebody? When you take those pants and you do it in the manner that Kelsie described, in the manner that the evidence shows, there is no other intent other than to do harm and to kill someone. Counsel also talked a little bit in his closing about the chair being up, possibly the chair was upright. Well, you can't have it both ways. You can't say, listen to everything Kelsie told you because she was telling the truth, because in that interview, that walkthrough interview, she says the chair was down. It was always down, and it was in the same way that it was. She said that. So do they want you to believe all of her versions or not believe them? Because they are all inconsistent, and that's something that you can consider. Consider why somebody's story keeps changing. Consider why there's so many inconsistencies. Like I told you before, we've proven the defendant guilty beyond a reasonable doubt. There is no other verdict in this case. And I'm not just asking you to find her guilty because we want you to or because the family wants you to, but because the evidence supports it, the law dictates it, and justice for Chloe demands it. Find the defendant guilty. Tell her that the laws in the state of Iowa are the laws that apply in this courtroom and the laws that apply to her. What she did that day was murder in the first degree and child endangerment resulting in death. Tell her that with your verdict.
We are now on the record in the case of State of Iowa versus Kelsie Ray Thomas, case FECR 011664. We are in the presence of counsel, the defendant, and the jury. The court has received a communication from the jury indicating that the jury is unable to reach a verdict on count 1, but is able to reach a verdict on count 2. I would ask the presiding juror to stand up. Mr. Presiding Juror, we're going to go count by count. As to count 1, is the jury able to reach a unanimous verdict?
No, we're not.
Would further deliberation be fruitless?
Yes, it would be.
Sir, you may be seated, and then we are going to have a polling of the jury. I'm going to have the court attendant ask each juror, have you reached a verdict, and would further deliberation be fruitless? So those are the questions. She doesn't have to reread the questions each time, but if each juror would just indicate the status of deliberations at this point.
Yes.
Just a minute. Maybe we should go question by question because that was not the response.
Okay.
So, first question, has the jury been able to reach a unanimous verdict
On count one.
on count one?
Yes.
No.
No.
Okay.
The jury,
Let me back up. I want the record to be absolutely clear. So I'll ask the questions each time and I'll have the court attendant indicate the names. So first question, has the jury been able to reach a unanimous verdict on count one? Please stand up, sir.
No.
Would further deliberation be fruitless?
Yes.
Sit down, sir.
Okay,
Thank you.
sorry.
Has the jury been able to reach a verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless? Has the jury been able to reach a unanimous verdict on count one?
No.
Would further deliberation be fruitless?
Yes.
Those are the 12 jurors. Position of the state. Go ahead, Mr. Knapp.
State remains neutral as it's noted in informal discussions. That being said, it is the state's understanding that it is within the court's discretion to rule on these matters as a matter of the court's discretion when a jury has noted that they cannot reach an agreement.
Position of the defense. Go ahead, Mr. Cooke.
Thank you, Your Honor. The defense realizes that the jury has put in a lot of time and effort into their deliberations, considering communications that have been given to the court indicating that they are unanimous in finding not guilty on count in alternative 1 and alternative 2 in count 1. The defense feels we are way too close to an outright acquittal to agree or to move to dismiss this jury on the basis of a mistrial. And for that record, Your Honor, I just cannot make that motion.
The court has heard the statements of the jury and the individual jurors. The court has heard the positions of counsel. The court finds that the jury now has been deliberating for in excess of 14 hours. Their deliberations have occurred over parts of 4 days and have included 2 full days. The court finds, with respect to count 1, which is murder in the first degree, that the jury has deliberated until it satisfactorily appears they cannot agree. So, pursuant to Iowa Rule of Criminal Procedure 2.19, subparagraph 6, I am discharging the jury with respect to count 1, and a mistrial is declared with respect to count 1. The jury is hung. Now, we will move to count 2, which is child endangerment causing death. Would the presiding juror please stand up? Mr. Presiding Juror, has the jury reached a verdict on count 2?
We have.
Is that verdict unanimous?
It is.
Please pass the verdict to the court attendant.
Hello.
The court will listen to the reading of the verdict of the jury as to count 2 by the court attendant.
In the Iowa District Court for Wapello County, State of Iowa, plaintiff versus Kelsie Ray Thomas, defendant, criminal number FECR 011664, verdict form, count 2. Alternative number 2, we, the jury, find the defendant, Kelsie Ray Thomas, not guilty under count 2. Signed by the presiding juror.
Members of the jury, your services are almost complete in this matter. I have just a few small issues to discuss with counsel, but at this point, I'm going to ask that you go back to the jury room to wait for a brief debriefing by myself. Sometimes jurors have questions about confidentiality of the proceedings. At this point, you are free to discuss the deliberations generally with anyone you choose. You should keep the privacy of what an individual juror said in the jury room to be confidential and not reveal that. But you can talk about